Hey, welcome to the show. How are you doing today? Funny.
Thanks, Gabe.
Yeah, pretty nice, huh? It looks like you're a little bit over prepared today for the podcast. We're just having a conversation.
Okay. Thanks for having me, man. This is awesome. It's actually something which I am passionate about, and thank you very much for allowing me the opportunity to come here. Tirani and Velez is very gracious, and thank goodness we have people like you that can help people in these waters and navigate them through them so that they don't end up with tax liability because their attorneys didn't tell them what to do while they were in a case. So
yeah, we definitely have a really good show today. We're going to be talking about the taxation of settlement, right? What's taxable, what's not taxable. This is a really relevant stuff. But I kind of want to get everything going and just kind of ask you what it is that a personal injury attorney, which is what you are.
Absolutely.
What do you do?
Actually, what I do, I help people to get back where they were before an accident. If people have been injured in an accident, they incur medical expenses, they lose time from work, they're disabled, they're going to need future care, they've been through pain, suffering, their lives have been disrupted. My job is to help people get back to where they were, help them to recover those losses, to compensate them for what they've been through. Sometimes there's liability disputes, and we're very helpful in helping people to recover when there's a pointing of fingers, when there is a question of what are the damages, how to prove those damages. What we end up doing is we end up acting like teachers. First we learn it, then we teach it. And if we don't know it, we can't teach. And if we can't teach it, we don't know it. That's sort of the way we talk about it. But what we do is get people where they need to be. And a lot of the time there's insurance companies involved to help people, but the insurance companies are looking at it from a business perspective, not looking at it from a human perspective. And I guess what we do is we kind of bring back that human perspective to the carriers.
Yeah. So we're located in Orange County, California. Los Angeles is just one county over. Very, very dense area. So I'm assuming a lot of your practice is actually coming from auto accidents, but it probably also stems from different sources, right?
Absolutely. We handle things that involve premises, trip and falls, slip and falls. We handle auto accidents. We handle animal attacks, dog bites, product liability claims. And actually, our practice covers a lot of the state. We do handle things in Riverside, San Bernardino, Orange County, San Diego, Los Angeles. And there's a couple of firms that we work with up in Northern California. And sometimes I fly up and do their litigation with them. So it's actually really cool.
Yeah.
So
fun trip.
Yeah, it's actually pretty neat. Handle cases in Oakland and Sacramento, San Francisco as well, but primarily down here in south part of the state.
Very cool. And then, are you more on the litigation side, or are you more on like the negotiation for settlement side? I
do both.
Yeah.
A lot of my work does involve litigation. The difference between litigation and pre-litigation. In pre-litigation, you're trying to resolve a claim through giving evidence to an insurance company and an adjuster and trying to reach a negotiated settlement. If that does not work, then you go to court, you present your evidence to a trier of fact, whether it's a judge or a jury or an arbitrator. And also when you go to litigation, you gather evidence through what's called discovery, where you request documents through subpoenas and you ask questions in written form to the other side, and you also take depositions, which is far more revealing than just simply, oh, here's my documents to the carrier.
Yeah.
So we do both. I actually participate quite a bit in both.
Yeah. So settlements, limited information.
Mm-hmm.
If you actually go to litigation.
Yeah, you have the power to obtain information through litigation that you do not have in pre-litigation. However, there are investigators, and I love some of these guys. They do some amazing stuff.
Yeah.
They find things that you just kind of scratch your head going, that's kind of scary. How do you find that? But they do a great job. But sometimes you just need to subpoena documents or have somebody testify and hear from the source.
Yeah, it's the information age. I mean, you can find anything out about anybody. It's really scary, and that's what Mark Zuckerberg was on trial the other day for, right?
Yeah, no
for
kidding.
Congress.
It is not our parents' world, and the advent of technology, I can't imagine what our kids are going to see. I mean, it's going to be so much different for them.
Yeah.
So it's exponential. It's pretty cool.
Yeah, it is pretty cool. That's progress, right? So. All right, so we're looking at it for the person who's being harmed, their perspective. Let's turn it around. Let's we're all out there driving. Driving is probably like one of the most dangerous activities that we do on a daily basis. And, we're maybe some of us are speeding a little bit, but for the most part, we're not trying to harm anybody. Right.
Correct.
So how do you best protect yourself, your assets, first from being sued, and then from also losing everything?
Well, that's an excellent question. First off, don't drive like a jerk. Be conscientious of others. I mean, we spend a lot of time on the road here in Southern California, and we tend to get a little aggro. Just take a breath. Somebody cuts you off, let them go.
Right.
Try not to take it out on the road. And when you're having a bad day, some people say go for a drive. I wouldn't suggest that. Go for a walk.
It's a little bit better. Walk in the park.
Exactly. And just watch out for other cars. One of the things that we just tend to forget is we look left, we look right, and then we think we're okay. We forget to look left again.
Yeah.
You look out for the motorcyclist in the corner. You look in your blind spots. Always watch a little bit more than you should. That's one way to be safe. But driver safety is a personal issue. I think everybody thinks they're safe, and everybody should continue to just be vigilant on the road.
Yeah.
When it comes to how to protect yourself, in California, we are required to protect ourselves. There's something called Proposition 213 in 1996, which was later codified in Civil Code Section 33.4. We have to have liability coverage. It is required. Now, the state minimum requirement is $15,000 per person, $30,000 per incident, meaning if someone with insurance has an accident, the maximum benefits under the minimum would be $15,000 for each individual. But if there's 10 individuals, the most under that minimum would be $30,000 divided whatever way, with a maximum of 15 to one person. I don't recommend the minimum. I recommend that you talk to your insurance agent and that you get what matches your value, your assets, your income. Somebody who is a high earner should not have a low policy, because those types of damages that you can cause inadvertent, you can't always protect your income if you have a small policy. So people who have greater assets should get greater policies, umbrella policies. And the one thing that is not required by the state, and one thing that insurance companies really don't like you buying, is uninsured motorist coverage, because it is such a cheap product line and it is so valuable. It's really kind of a lost leader, I think, for them. The more insurance you buy, the more uninsured motorists you can purchase. It has to be the same. The most you can buy is the same limits as your liability. If you are hit by someone that does not have insurance and you have uninsured motorist, great, you're covered. But if you don't have uninsured motorist and you just have liability and someone else hits you, that's a tough situation. Now you're going after someone who doesn't have insurance. You're looking at trying to get their assets. By and large, most of these claims are dischargeable in bankruptcy if you have no assets. When I say by and large, because if it involves alcohol, then it's not dischargeable, even if it's not a punitive damage. But when you have uninsured motorist, you avoid all that. Me personally, I buy auto insurance just like everybody else. I have $1 million policy for liability because I want to buy $1 million of uninsured motorist, because if somebody hits me, I want my family protected.
Yeah.
So that's what I would recommend. But insurance agents are awesome for that. And, we know some guys.
Yeah, exactly. Right. Okay. And so, all right. So you got damages, you got insurance to try and kind of cover some of those expenses in case, you're at fault or you're struck by an uninsured motorist.
Correct.
Right. Okay.
One other thing, if I may.
Yeah, absolutely.
When you get an accident, it's not the lottery. You don't sit on the couch and eat bonbons and wait for this huge check to come in. You have a duty to what's called mitigate damages. You have to try to avoid consequential damages that are otherwise avoidable. So if you're hurt and you can't work for a period of time, that should be compensated. That should be paid for. However, if at a certain point you're ready to go back to work, you go back to work. If you're physically and mentally, capable, because that is your duty. You can't just sit there and go, woohoo, I've hit it, I'm styling. That doesn't work that way. You have to be genuine. You have to be congruent. You have to make sure that you do avoid the damages that you can avoid.
Yeah. Okay. So it's not the lottery.
Exactly. But people
Yeah.
should get compensated. There's absolutely, like the case we'll talk about today, even though the harms weren't substantial, the actions were egregious, and yeah, it was something that really ought not to have happened. But we'll talk about details because that's what we want to talk about today.
That's what we want to talk about. Okay. So let's say I'm the injured person, right? When is it best for me to kind of try and take something to trial, and when is it best to kind of negotiate and then brush it off and move on?
Another great question. What you want to do is you want to look at benefit versus risk and cost. So I had a case. A gentleman was working as an electrician at a construction site. Another subcontractor was installing air conditioning units. Didn't put the bolts in right, and the unit fell down and hit my guy.
Yeah.
The defense really did not buy into any of it. They just had this conspiracy theory. And it was really driven by the handling attorney, I think, at the time. It was just a real battle for every step of the way. In that case, it was such an easy decision to go to trial. We had a zero offer on the table, and we had a significant injury. Jury came back with, I think, like $500,000 or $600,000 verdict. And I should know the verdict. It was me. It was like 550,000. And what happened was that was an easy decision simply because the carrier had said no. They drew a line in the sand and said there's no payment on this case whatsoever.
Wow.
And when we do take a case to trial, we spend a lot of money. I mean, I spend anywhere from $25,000 to $100,000 of my company's own money out of pocket to pay for experts, to pay for the court reporter, to pay for the trial courtroom, things like that. So for us, there's also a substantial investment. Now, I'll give you the converse. You have a case where somebody has an injury. There's a couple $100,000 being offered. The risk that a jury could come back one way versus another way, and the cost of it, and is the value of the case so much so that it outweighs the risks and benefits. So it's really something you have to weigh. And sometimes you have to go to verdict, and you have to see what the value is from a jury. Sometimes you have to say, okay, well, I think this is probably best because even if a jury award came back, I don't know that the value would exceed the expenses and the amount that we're looking at on top of it as part of the pot. So it's really an analysis that has to go into each case.
Mm-hmm. So what's court like? I mean, we've all probably sat on one or two trials. Is it like what we see in the movies? Is it like Law and Order? What is it like?
It's so much like that now. Actually, I really enjoyed Boston Legal because I loved what Shatner and James Spader did. They were awesome because they were so off the beaten path.
Yeah.
But no, it's not like that. It's actually kind of dry.
Oh, yeah.
When you're a juror,
yeah,
you're staring at the walls, just hoping that something important or something interesting will be shown at you, as opposed to, so could you please give me your background information, doctor? And they're falling asleep.
Right.
So you really want to try and make it as interesting as possible for people who are stuck watching your case.
Sure.
And we try to do that. We put animations, we put props like physical things to touch. We try to make it so that we're not monotone.
Right.
But for an attorney, it's actually pretty cool because that is our little domain, and you speak the language of the judge. First off, the judge is the king, and
what he says goes.
What he or she says goes, yeah. And you do what that person. And of course, you're going to have times when you disagree, Your Honor. I respectfully disagree. However, I would like to point out, and if you say it that way, you're following procedure. If you say, Your Honor, you got to be kidding me.
Yeah.
Yeah, not so much. The one thing about trials that's really fun for me is it's very much being alive. Like the first 10 seconds of every trial, when that jury walks in, and that first 10 seconds that I get to address them is the only time I'm very scared. That's the only time I'm scared is like that 10 seconds.
Sure, yeah.
And then after that, everything's just normal. But 10 seconds of just, but that means that I'm alive. That means that I'm involved. It means that I'm connected to what we're doing because I understand the import of what we're doing. The rest of the time, it's like just old hat to hang out in a courtroom and see your friends and your opposing counsels and, just do your thing.
Yeah, and when you're dealing with like physical injuries, you probably have to educate the jury on like what the lasting effects of this injury are, a little bit of the science behind it, make it interesting.
And that is actually really fun.
Yeah.
But sometimes you get so technical that people, again, you lose them. So you have to make it in terms that people can equate. One of my favorite questions to an expert is, Doctor, can you tell us what that means in layman terms?
Right.
And I'm not afraid to admit, hey, that's more complicated than I understand. Could you explain it to me so I could explain it to someone else?
Right.
And people don't realize when they're working on that level that the rest of us are just, trying to keep up. One of my favorite experts, he is extremely smart and he does a great job of explaining things, but he loses me about 20% of the time. And I'll say, okay, Doc, I got everything you told me, but could you please dumb down that last sentence so that I can get what you're telling me?
Right.
Because, and he doesn't do it on purpose. He's not trying to speak over people, but he is just so well-versed in the terminology that he doesn't realize he's doing it. And he's like, oh, okay. Because I know you keep up with all this stuff. I'm like, I do up to a certain point. I don't have an MD. I got a JD.
Right.
So I do kind of need you to put it into my terms for a bit. Oh, well, it means this. Okay, thanks. Perfect. And, it's kind of cool because if you have an ego and you don't ask and then you pretend to know, again, you're not being genuine and people sense that and you lose your own credibility.
Right.
You have to be credible with other people. So it's a fun thing. I actually had a judge once. I'm going to totally go off
here
for a second. I had a judge once and we had a trial. That was like a 2-week trial. And this judge would say things and I would get 90% of what he said and 10% of it would just like be these obscure references. And we got to the end of the trial and I told the judge, he said something about girding loins. I'd never heard that term. Oh, okay. Gird your loins. So I at the end of the trial, I said, Judge, thanks for a great trial. But, about 10% of what you said, I didn't get. Like, gird your loins. What does that mean? He goes, I looked it up after I said it, and it didn't mean what I thought it meant. I'm like, well, thanks, Judge. Okay.
Yeah. Do you know what it means? Or
apparently it was going to kick me in the groin.
Oh, what? No. I don't think that's what it means. I don't know.
It means protect your groin or something.
No. I think so. And everybody listening at home, like I'm going off the cuff here, so correct. You're going to be able to correct me if I'm wrong, right? You're the judge out there, but I believe it has to do with a culture, probably the Romans who used to wear skirts as men. Mm-hmm. Okay, and when they went to battle, they would have to actually take the inside of the skirt, bring it up, and tie it to like make pants so that they could actually go out to battle. But I might be wrong. I might be actually picking the wrong culture. But
I think your information's better than mine.
I'm pretty sure that's what it's about, but I don't know. Okay. Moving on. Okay. So a lot of these cases, you're talking about hundreds of thousands of dollars. Mm-hmm. And so you talked about like the lottery and stuff like that. So obviously there are people who try and manipulate the system and go out there and sue.
Yeah.
Right?
And those people, you really try to weed those things out as early as possible.
Yeah.
It's never the type of thing that you really want to find yourself affiliated with. My office works very hard to make sure that, we can validate what we're talking about. And if we don't validate it, we've got, we'll respectfully, part ways.
Yeah.
So, you really do need to be vigilant as an attorney, but people who are involved in accidents, if you're hurt, if you're not, don't make a claim. I tell people this all the time. If you're hurt, take care of it. If you're not hurt, count your blessings.
Yeah.
And don't do it because it's not something, if you make a false claim, that is a crime. It's punishable by fines and prison. Mm-hmm. So, there's no reason to do that. And frankly, somebody who's hurt, this is not an easy process.
Right.
You're scrutinized. The insurance companies hire people to videotape you. You get videotaped wherever you go, whether you're in shopping center, or even if they can get a view into your backyard. It's very creepy.
Right.
They look at your Facebook now.
Mm-hmm.
They look at your Instagram, which is one of the biggest negatives for people in the modern age. A lot of people who are hurt, but they're still trying to live a normal life, are posting, hey, you know, I got to go hang out with my friends today. They're having a good day.
Right.
Well, the insurance companies or the defense counsels will download that, put it in front of a jury and saying, is this somebody who's really hurt? They're out there having fun with their friends and they're claiming that they have this pain.
Yeah.
So, you know, that type of thing, your life is now being scrutinized, and that stinks. And they're ordering records about you from 10 years before. They're finding out about all kinds of information in your past. They're looking at your medical stuff. And heaven forbid you should have anything in your medical that's not accident related, that's embarrassing.
Yeah.
Whose business is that?
Right.
But they make it their business. So I always recommend to people, if you're injured, know what you're getting into. That's fine. If you're not, count your blessings. Stay out of it.
Mm-hmm.
You know, that's the way it should be.
Yeah. How about, well, most people are law-abiding citizens for the most part. You know, they're not trying to go out there, right?
99.9, yes, percent.
But a lot of people are kind of scared of being sued. Like, is there anything you can do to protect yourself from being sued, or is it just?
Yeah, I guess what we said before about having the proper coverage.
Yeah.
It's always good to have a lawyer in the family. If you find yourself involved in a incident, talk to your insurance adjusters. They actually are the first line of defense for you. They'll assign an attorney if need be. If it's a situation where it's really catastrophic and you just don't have the resources, you talk to a bankruptcy guy, figure out what's the best way to protect your assets. But, you know, by and large, people who work in my industry, we're not hoping to go after an individual's assets. We're hoping to have coverage for whatever the harms are.
Yeah. Because
it's really unpleasant to want to go after somebody's assets. You know, it's not a real cool human thing.
Yeah, and then you know, a kind of public service announcement, right? It's not just auto coverage that you need, right? So if somebody harms themselves on your property,
homeowners coverage,
yeah.
And make sure your homeowners coverage covers the type of animal you own. Some homeowners actually coverages don't cover certain breeds of dogs.
Wow. Okay.
So, you know, if you have a type that's known to be aggressive, make sure that your policy covers it. I actually had a case where somebody took someone else's medications at their home and overdosed accidentally. And there was a clause about no drug-related coverage for this. Technically what happened, though, we were able to circumvent that clause in the policy because the drug that had been involved hadn't even been classified as a drug yet. So because of the timing, we were able to get the coverage. It was a really interesting issue. As far as other ways to protect yourself, stuff happens in life. Just be prepared, you know.
Stay away from shady people.
Yeah. Boy Scouts, always be prepared.
Always be prepared.
So.
Great. Okay. Is there anything else that you'd like to share before we actually get into the topic of the day, which is taxation and kind of, you know, bringing it a little bit between our two worlds?
The only thing I'd like to share is, you know, lawyers were children once too. I don't
know. oh, you guys are humans. You're not just yeah. Exactly.
I'm having fun. No, let's talk about how Dennis Rodman changed the tax world and the tax code and personal injury law. It's actually a very fascinating thing. I actually like this case simply because it's something that we can actually see what happened.
Right.
And it impacts every single state in the union because it's federal law. And I think it's something that's underappreciated by guys who do what I do, guys and gals.
Yeah.
Men and women. So.
All right. So let's kick it off. Those of you who are actually able to see us, right, versus the people who are just listening, I'll go ahead and describe what's going on as we bring up this videotape. So what is this? Like 1995?
Actually, it's January of 97.
Okay.
It's the Bulls versus the Timberwolves.
Okay.
And it's Dennis Rodman trying to get a rebound, and he goes beyond the baseline and hurts himself, and his foot is right next to a guy named Mr. Amos.
Yep.
And he decides to just kick him, and then the other thing he does is he stands over and he tries to intimidate him.
Right.
And you can see Mr. Amos on the ground there rolling over, and even one of the announcers says something about, this is going to be a payday of some sort, which was, I thought, kind of a derogatory remark. But, what Rodman does there is pretty deliberate. And, I've seen interviews where he says sort of the heat of the moment kind of thing. It just sort of happened. And, that's still pretty mean. I mean, it's still pretty powerful to just sit there and get kicked and then be, looked down upon and growled at, and then have people pull him away. And then you see Rodman in the video. He just kind of
rolls his eyes.
Exactly.
Like, oh, you got to be kidding me.
Yeah, exactly. And it's sort of insult to injury.
Right.
You and I talked a little bit beforehand. Even though the injury is modest, the fact that the injured party contacted a lawyer so quickly kind of made me go, well. But, I'm always one to advocate getting counsel early to, handle things. But, it was pretty clear what happened. It was all on video.
Yeah, exactly. The whole world saw it.
Yeah. But, the guy got hurt, and he was humiliated. He's actually taken from this scene on a stretcher, and he's taken by ambulance from this location. So, that's really embarrassing, and when people fall or when people get in accidents, all of a sudden, they're embarrassed by the fact that they were the victims. And it's a weird society thing. We look at people like, well, you shouldn't have been in the first place. Really? Right. That's not the way it works. You shouldn't have kicked them. Shouldn't have done that. But nonetheless.
Yeah, I think I read, part of the case that he actually had some pre-existing conditions or pre-existing injuries before actually getting kicked in the groin.
What happened was he had a pre-existing back condition that they were wondering if it was aggravated or not. And having a pre-existing condition is not a compensable damage, but having that condition worsened or aggravated is compensable. So at least under California law. I'm sure some other states might be looking at this. Yeah. But under California law, an aggravation of pre-existing condition, that change in the condition is compensable. Now, under California law, you don't have to make that underlying condition better. You just have to make it as good as it was prior to the incident. Right. The interesting thing also about the Amos case is they resolved it within 6 days. That's kind of a speed record.
Yeah, it was a quick settlement, right? Rodman basically wanted to cut the check and get it over with and get it out behind him. Yeah.
And what happened was, in the process, they had come up with a number, and that number was supposed to be confidential. Yeah. But it's not. It's $200,000.
How'd that happen?
Yeah. What happened was an audit.
An audit, and then they appealed it, and then it went to US tax court.
What happened was he paid them this $200,000, and under the Internal Revenue Code, I think it's 104A2. Is that right?
104A3 is the one about personal injuries.
Okay, and basically, when you have an injury, a physical injury caused by something, there's compensation. That doesn't become income, correct?
That's correct. Yeah, exactly.
And that means that the recovery in an accident generally is non-taxable. Right. There are some exceptions.
Correct.
One of the exceptions was created by this case, or at least crystallized in this case. Yep. When you pay someone damages, but you also ask them to be confidential about the damages, you're not just paying them for their harm, you're also paying for them to stay quiet. It's sort of a contract, a service, not to open your mouth. Yep. And that's what the IRS took issue with on the Amos case. They said, well, you have this income, and since you did not differentiate in the settlement agreement how much of it was for your pain and suffering and how much of it was for your confidentiality, right. We're going to say $1 for your injury.
Yeah, auditors great.
Yeah, auditors did that. And the other $199,999 is all taxable income.
Yeah.
Which also made me scratch my head, because he did not receive all $200,000. he had to pay some expenses. He had to pay medical bills. He had to pay an attorney.
Yeah.
What that guy actually netted, what Mr. Amos actually netted, it didn't go into his bank account. The $200,000 didn't go to his bank account. The portion after all the other charges would have been. So to me, that was like, I don't think that other stuff would be taxable because he never received or had a right to receive a portion of it. So to me, the taxable portion of it, or at least the portion in question, shouldn't have been $200,000 from the get-go. But that's what they said. And then they went to an appeal. They went to tax court, and the tax court said, well, we actually think that some of it is for your pain, more than $1 worth, and some of it is for you to not disclose. And I think they went with a 60-40 split. 60% of it, or $120,000, was for your injuries, and 40% of it, or $80,000, was for you not to tell the police anything, not to tell the papers, not to tell the media.
Right.
That not telling the police thing, actually, that's part of it, because Mr. Amos had filed criminal charges against Mr. Rodman for the incident. It was a battery. It really was.
Right.
And absolutely, it should have been criminal. I mean, he had no right kicking a guy. That's a crime. But part of the deal that Mr. Rodman was trying to make was that he not cooperate with prosecutors, because if they don't have a victim, there's no way to prove the crime.
Right.
Well, I'm not a criminal attorney, so maybe there is. I don't know. By and large, though, I would say without him testifying, how are they going to be able to prove it? So that was part of what he was buying. Also, part of what he was buying was he didn't want this stuff splashed all over the world.
Right.
Well, wow, because of that confidentiality clause, it actually was the opposite. In 1997, that came down, and as a result, there is now taxability in otherwise non-taxable recoveries in personal injury cases if there's a confidentiality clause. So one of the things that I do in my job is I negotiate settlements. I negotiate with all types of people. And one of the things now I negotiate for the past, 15 years has been, I've been involved for 20 years, so it'll be 20 years, is now whether or not there's a confidentiality clause. And when I go to a mediation or I go into some sort of settlement, I'll tell them right off the bat, we will not engage in a confidentiality clause because of the tax consequences.
Yeah.
And there was some holdings, I'm sorry, not some holdings, but there were some suggestions as to how to circumvent making it all taxable. And one of the suggestions that I had seen or been told is, well, why don't we just differentiate? We'll make X number of dollars for the injury and X number of dollars for the confidentiality.
Yeah.
Okay, well, I don't think a case has really exactly said that's doable. I know that they have intimated it. They've kind of said it in this case a little bit.
Right.
But I didn't see a case on point yet. There may be.
Right. Well, it's a matter of if you've already placed a value on there, you're going to have a better chance of that number holding up. But the IRS can always come back and rule against you and reallocate things.
Correct.
And so you might also, I'm not an attorney, but you might also want to put in a stipulation that if an audit were to occur and they actually come back and reassess that line, right? So like you thought it was 60-40, they think it's 50-50. Well, then, whoever actually paid out the settlement would come back and pay the tax on that.
Yeah, it's an indemnity clause,
right?
Indemnify and defend.
There you go.
It's really hard to get them to agree to it.
They want you to go away.
Oh yeah, and they ask for indemnity from me all the time.
Yeah.
And frankly, if my client has an unpaid bill and somebody sues the defendant for that unpaid bill, my client is responsible. So we do indemnify for that because we know that we have to cover the bills. However, I will not indemnify for other things. I will not defend them. I will not defend them for claims that are brought that have no merit. I will not do any of my client will not agree to that. And that's always a point of contention. Right. As far as the confidentiality, that's a point of contention as well. We actually have, I agree with your assessment that, let's say a case goes to verdict and you have a fixed number. That helps to do things like that. Or if you have an arbitration, you have a fixed number. One of the other suggestions that came along was, okay, well, if they want it taxable, increase the settlement.
Money solves everything, right?
Exactly.
Yeah.
But again, that's something that's going to see a little bit of pushback from most defense positions.
Yeah.
But the Rodman case was kind of a landmark case, and I just don't think a lot of people are it's on their radar. In fact, when I go to arbitrations or mediations, or I bring it up with people when we try to resolve cases, and they ask me about the confidentiality clause, I don't know if they're being deliberately obtuse that they don't know about this case, or they really don't know about this case.
Yeah.
And you have to be in the know, because if your clients are relying on your knowledge and you're unfamiliar with this, it's important to know. And you could create a liability for them, which creates liability.
I mean, they
for
might
you.
just be testing the waters to see if you know, right? So that they can kind of lowball. And
I have sent copies of the Amos case to so many people.
Yeah.
Well, do you have a way of getting around what's in there? You know what? We'll back off on the confidentiality. Thank you.
Yeah. Exactly.
Also, sometimes they try to get around it by saying a mutual confidentiality, and I don't see anything in the case law that I'm aware of that makes the mutual confidentiality. In fact, I would think that it would now create some sort of liability for the defendant if there's some sort of actual benefit. But
yeah, like a barter.
Yeah, it's like a barter.
Yeah.
I don't see that being a solution to this, but some people
Barters
try.
are taxable too, people. Actually, everything is taxable unless the tax code says it's not taxable, and you know that includes most legal settlements except for actual physical injury.
Mm-hmm. And you have to have a physical injury if it's just a non-physical injury,
right?
Or punitive damages that are to punish and deter certain behaviors.
Yep.
Those are not for pain that you have for a physical injury, so those are taxable as well.
Right.
So yeah, there's like you say, everything's taxable unless there's an exception.
Exactly.
And this is an exception, and the Rodman case can bump you out of that exception without you even knowing it.
Mm-hmm.
And that is something that we should all be aware of in our industries, yours and mine, because I'm sure your clients say, well, I just got a settlement, and okay, can I see that settlement agreement? Is there anything in there that I should know about?
Right. Yeah. Do we need a? Yeah. Exactly.
Yeah.
It's super important.
And frankly, most settlements, people don't care.
Right.
That's the weird thing. It's like, all right, how much do people actually go, oh, I really want to know how much this auto accident settled for? It's really not all that. People in the general public are really not all that interested. Sometimes they are. I think what happens is, by and large, attorneys like to promote how well they do for their clients.
Mm-hmm.
So we have reporters reporting books that we can list, verdicts and settlements. And I think it's more of a deterrent for us than it is for the clients. And, you know, if you have an ego, it's going to be tough to say, you know, I'm not going to publish this.
Yeah.
But, you know, I let people know that most of my settlements are unpublished. I mean, I think there's maybe like a couple from years and years back that, you know, and they weren't, you know, landmark cases. So things like that.
All right.
So it's actually a really cool thing to be aware of, and it's a really cool thing to kind of delve into. The weird stuff that happens in cases, when a case comes in the door, you have no idea what direction it may take. I've had a case or two where someone, let's say, fell. I had a case where someone fell and hurt themselves. And the judge ruled on a motion for summary judgment, and we lost. And I'm like, Your Honor, your view of the evidence is completely contrary to what the law says you can do. Well, whatever. Take it up on appeal. Okay.
Summary judgment, meaning the judge called the case and
Mm-hmm.
pretty much dismissed it.
Yeah, you can try to get rid of cases or dispose of issues through pretrial motions, and you say, based on all this evidence that we have, this is everything that we're going to see at trial. There is no way for anyone to award in this case, because even if you take everything that we have, they still cannot meet all of their elements. And if a judge agrees with that, then case is gone.
Yeah.
If a judge disagrees, you continue. Or you can do it the other way. You know, Your Honor, based on the evidence that we have, we will get this liability. Now it's just a question of the damage. You know, you can do it that way as well. But we've had cases where I had one case where someone had lost. She lost because the law was against her. And we knew the law was against her when we took the case. And we said, we're going to take this case and see if we can't change the law. And we did. And we went to multiple hearings, and we were bounced out of the case. We were dismissed after the third demur. And the judge was telling me, Mr. Lazarus, if you just plead it differently, I'll let you stay in here. And I would tell the judge, Your Honor, that's not our fact pattern. I cannot plead that because I don't have such evidence. Yeah. This is our fact pattern, and this is a case that has to be heard this way. So we ended up getting dismissed, going up on appeal, and we were just about to make California law. This was going to be the stare decisis. This was going to be the case that would define this particular issue. And sure enough, there was one case that was 2 months ahead of us and changed it right before we did.
No way. Yeah.
So we're like, we win anyways. But
it would have been better to have your name on that case, right?
Yeah, it's all right.
You'll get them next time.
We do our jobs well, so we're okay. We don't have that ego need.
Yeah.
So it was actually, deliberately expected that we would lose, and and we wanted to change things because it was a wrong finding. And there were two cases in similar positions at the same time. Who would have figured?
Right.
So that's kind of cool.
Yeah. Super cool. Okay. So we've been going for kind of a little while now, and so I'm going to start wrapping it up, and usually play this either word definition or word association game towards the end. I throw out some terms.
Great.
You can define them, or you can actually provide us with
Okay, as long as I don't have to act them out.
Funny story.
Shoot.
Okay. Uninsured motorist.
Someone who is driving without liability coverage. And if you are an uninsured motorist and you get into an accident, there are a lot of negative consequences in the state of California. First off, you're going to be personally liable for whatever the damage you cause. Yeah. Second off, you're likely to lose your license for a year. Third, you're likely to get fined by the state of California. Fourth, if you are hurt and you're uninsured, even if the accident isn't your fault, you lose your rights to pain and suffering. You only can collect your out-of-pocket expenses. That's the Prop 213 thing that came down. Yeah. If you don't own the insurance that you're supposed to buy, Civil Code Section 3333.4, then you don't get your pain and suffering. Now, almost every statute has an exception. The exception to that one is unless you're hit by a drunk driver. So if you're uninsured and hit by a drunk driver, it doesn't apply. It's just, but uninsured motorists, yes. Don't be one.
Okay, so sum it up, dummy. Don't be a dummy. Don't be an uninsured motorist.
We prefer the term knucklehead.
Knucklehead. Okay.
Yeah,
all right.
That's less politically incorrect.
Uh-oh.
I don't know. I'm messing, man.
Dummy's okay too, I think.
Yeah, it's totally okay.
All right. So a tort.
A tort. A tort is a fancy way of saying a wrongful act.
Yeah.
It sounds much better if you say there's a tortfeasor as opposed to a defendant. Torts are harmful acts, whether intentional or negligent, that result in damages for which there's a remedy. It can be, just simple negligence, a momentary lapse of vigilance and causing someone harm and you have an accident. Or it could be intentional, where you meant to hurt someone, where you threw something at them, you punched them, or you tried to cause them harm. You sicked the dogs on them, unleashed the hounds. So those are torts.
Mr. Burns reference.
I love that.
Smithers, release the hounds. Personal injury.
Personal injury. When someone gets hurt from someone else's negligence or intentional acts that results in them having pain, suffering, out-of-pocket expenses.
Okay. Attorneys?
Could we go back to knuckleheads now?
Knuckleheads.
Attorneys are people who help other people. They're supposed to be advocates. They're supposed to be putting their clients ahead of themselves.
Okay.
Hopefully that's what they are. They're people who are supposed to have specific knowledge and fiduciary ethics to help people that come to them with their specific needs. And sometimes people forget why they're here. Sometimes they think the almighty dollar, which, it's a job,
Right.
but you got to love what you do, and you got to love people, and you have to want to help people. And when people come to us, they're in a pretty bad state. So, you have to have patience. You have to be willing to be more than just an advocate. You have to sometimes be just a listener, sometimes be a friend, sometimes take the attorney hat off and just say, hey, you know what, from a non-attorney point of view as your friend, I really think that you might want to consider this. And you be human.
Yeah. So empathetic knucklehead.
Yeah.
Okay. Moving on. Punitive damages.
Punish and deter.
Yeah.
We have actions that we think are so egregious. Example, kicking a guy when he's down, like Rodman did.
Yeah.
There was a potential for punitive damages. I think part of that $200,000 took into consideration that if Mr. Amos had filed an action, had taken it to court, and you have that video, that's some pretty, damning stuff that would result in potential punitives. You could tell he meant to hit him, and he stood over him to intimidate him. Okay, I get it's the heat of the moment. I get you're an athlete. You got adrenaline going, but you're also a professional.
Right.
So, yeah, punitive damages are to stop people from doing things that they ought not to do. So those are the definitions. That's kind of a cool thing. I like doing that.
Yeah, very cool. So where do people find you?
We are in Newport Beach. We also have offices in Long Beach and Riverside, but our main office is Newport Beach. It's Russell and Lazarus. I've been with the company for 17 years. One of the principals, and they can contact us. I can give out a phone number, or they can look online. They can Yelp us. They can Google us.
Whatever the best way is for them to find you.
Great. Our phone number is 949-851-0222 in Newport Beach, right by John Wayne Airport. We've been there a long time. We're going to be a long time more.
Yep.
And like I said, we love what we do. So thank you for having us, man. It's really, really a blessing. Thank you.
It was great to have you.
Oh, thank you, brother.
Thank you, sir.
Cool.
All right.